All right, let's go ahead and get started. So we've done our class review. I think you're at least caught up on questions. We'll just do our administrivia and then move through. We have a fair few cases to get through since we took the whole class period last time with questions. On administrivia, there's only one, which is I just wanted to check with you. Obviously, the 13th, we are now set to have a makeup class from 9 to 11 per your request. That will avoid the need for a Saturday class. The question then is, when do we want to have the other? We have to have one other makeup class. When do you want to have that? The other date that was recommended was the 27th from 10 to 12. Is that something that works with you all to do another one of those double class periods instead of a Saturday? Is there a reason off the top of your head why 10 to 12 on that Monday doesn't work? Okay. Okay, cool. Then that'll do it. Then that'll be done, and that'll be lovely because we will be substantially ahead of the class schedule, which means that once we hit the break, you'll be done with the lecture portion of the class. You can focus entirely on your outlining and questions for me. I will remain available, even though I am out of the country. I will remain available. I will meet with you by Zoom, meet with your study groups, go through any questions you've got. I know there are a number of you who've been doing exam questions now from the beginning. That's fantastic, and meeting with me. We will continue through the break, including during the break. Don't think you don't need to get in touch with me during the break. The only time I'll be strictly out of touch, or at least only in touch by text, will be when I'm on the plane over the Pacific. Sometimes, except when there's right over Hawaii. But otherwise, I have access to the internet. But otherwise, it'll be a little rough. But other than that trip, other than that specific time period, I should be available to answer your questions. Okay, Chris, you had a question.
So your preferred method of contact is to go through your assistant?
For
Setting up a Zoom call?
The best way to set up a Zoom call is to simply put yourself on my calendar using Outlook. Send me a calendar invite. You might there's a very rare chance that you might get a response back from me saying, hey, I thought that was going to work, but I need to adjust the time. But generally speaking, you'll just say, hey, my study group would like to meet, and I'll say, yep, and then we'll get in. My Zoom number will always be the same. It's always going to be wlu.zoom.us, that's for Zoom, /my/Josh Fairfield. Always going to be the same whenever you have a Zoom call arranged with me. Any other administrivia questions? I saw at least one other hand. Yeah, go ahead.
I was just going to say that you don't need to take our calls during Thanksgiving dinner.
I mean, I'll be in New Zealand. It's not going to be Thanksgiving dinner there. It will be 3 o'clock in the morning, but Love it. Any other questions? Great. Then let's dig back in. So if you remember where we were in the class, our 5 topics are contract formation, formalization, interpretation, defenses, remedies. We're at interpretation of the contract terms, the terms of the contract. We split the section on contract interpretation into 2 parts. Interpretation part 1, how do we understand the terms of the meaning of the express terms in the contract, the words that are written in the contract. Part 2, where we are now, is how do we interpret the words that aren't written in the contract? How do we fill the gaps? How do we add terms that clearly should have been there, but the parties didn't think about or didn't include? And we're going to move through 2 types today. Some stuff under the common law, which largely includes, 1, just what is going to happen when the courts clearly decide the parties have done enough sun printing work to conclude that there is an agreement, but they've left something critical out. And the answer to that is pretty straightforward. The court will supply a reasonable term under the circumstances. And then the other part is going to be some implied terms mostly from the Uniform Commercial Code, although there's one for the common law, which is we've already met, which is that implied obligation of good faith, which is considered to be part of every contract. And so we'll look at that implied obligation of good faith, but we've done good faith so much because we needed it all the way back in illusoriness in formation. Nothing's going to be a surprise here. In fact, we've even gotten the key standard that Professor Burton lists in the case. We've been working on that for a couple of weeks already, so we're more or less done with that. And then we'll move into the Uniform Commercial Code, which, because the Uniform Commercial Code is the dark side of the force, right? Quicker, easier, more seductive, clearly anticipates the parties having bigger contracts for more money over longer periods of time with more gaps to fill. Then there are some pretty famous gap fillers that get added to these contracts. And we'll take a look at that in terms of 2.3.13, 2.3.14, and 2.3.15, which are your terms sections of the Uniform Commercial Code. If 2201, 2202, and 2207 are your formation knot of questions you really need to know. Similarly now, 2.3.13, 2.3.14, 2.3.15, and 2.3.16, that's the block that you need to know for terms. That's all we're going to do. Any questions on that? Yeah, Liam.
I have a question about, it's kind of in reference to parole evidence as well. So if you're able to successfully lever the formation to an earlier point,
Yes,
because you want some term that you formed earlier to be included.
or you want to be able to prove it past the parole evidence rule.
Yeah.
Yep.
Yeah, you want to, yeah. How do the later terms that you might have signed off on, but you actually didn't want, how do those then get applied?
Yeah, it becomes a series of cascading problems, right? Because everything you sign later is an indication of another statute of frauds problem, right? You often need a writing for modifications. Remember, any contract you need a writing in the first case, you need a writing to modify. Also, many contracts, including under the Uniform Commercial Code, almost all contracts, have a provision saying any changes to this document must be in writing. And so let's say you pull that lever, you get formation at time one. That does create a nice escape for any conversation you had about modifying the terms orally. Those are no longer blocked by the parole evidence rule. But they may run into your statute of frauds problem because you needed to have a statute of frauds writing to modify a contract that originally needed a statute of frauds writing. And I'll add one bar exam and practice tip. One thing they love to do, although it happens less and less now to lawyers in real practice, is they'll give you a UCC case where you didn't need a writing at time one because the amount was below $500. But then they make a modification where you order more stuff or require more customization or have additional delivery charges or something. And so it takes the cost over $500. And I just need you to know you need a statute of frauds writing now. So that's one of the places that they love to sort of test you on that. But the basic problem is you need that statute of frauds writing. And then once you get it, it's going to be considered to be integrated, right? Or merged potentially against that oral representation that happened in the meantime. And this is a problem because I want you to see the real pattern. Let's say you have a deal and you've pushed that lever all the way over to get that deal at time A, right? Now let's say we have an oral conversation saying, we need to change this. Let's talk about how we're going to change it. We go back and forth. We fire off some emails. We get on the phone. We talk about it, right? That's time B. During that time B, somebody says something that later on you very much want to have be part of the contract. But then at time C, we either do or do not sign a document that deals with it. Now, if we sign a document that has the term you wanted in part B, then you don't really have a problem, right? But if you don't have a writing with that in it, then you've got one of two issues. Either you don't have a writing, at which point you have a statute of frauds issue, right? And you need to figure out an exception to the statute of frauds. Or you do have a writing, at which point you've got a parole evidence issue. because now you've got to figure out a way, an exception to the parole evidence rule to get past it. So what I need you to do in combining 2206 and 7, those are your contract formation rules, and 2201 and 2, 2201 is your statute of frauds rule, 2202 is your parole evidence rule, is exactly the question you ask. Get straight in your head how this is going to work as these long-term supply industrial contracts that go on for years get modified, and think about it and go look at the exams, because that is one I ask, I don't know, like every other year, right? I'm going to give a series of cascading negotiations during which the parties also exchange various writings that might count as a statute of frauds writing, and they might have representations that maybe apply to some exception to the parole evidence rule. I will give you one piece of advice as you navigate that, and I will say it again, don't cross the streams. With the Ghostbusters, we do not cross the streams. Ask yourself, is there a contract? Was it formed? Question 1. Question 2, do I have a writing such that it is enforceable? I didn't ask whether that writing had the terms you were trying to enforce. I just asked whether it existed and was signed by the party you're trying to sue. Do you have a document, whether a single document or multiple, right? Remember Sortino watches, Midgerobe? Or multiple documents stapled together that satisfy that writing requirement. And then third, is the term you're trying to talk about in the writing? Great. If it's not, can you prove its existence past the parole evidence rule? And we're going to use the various tools you got. You will go mad if you try to answer those questions at the same time. Separate the hazards, like when you're driving, right? Hit them one at a time. Is there a contract? Cool. Is it enforceable because I've got a writing? Cool. Can I prove any oral or extrinsic meaning past the terms of that writing? Cool. 3 separate questions. Don't merge them. All right. More. Anything else on this recent stuff? Yeah, Chris. What's that? Oh, can you prove any extrinsic or oral or other negotiation terms that do not appear in the contract past the parole evidence rule?
So that's like the Arnold Palmer case?
No, Arnold Palmer is purely about whether the letter of intent actually was a contract or not.
Or what about like the shaking hands and stuff? Like on TV and like saying we have a deal?
Sure, that's great. They shook hands. Which question am I asking? Was there a contract? Answer, fist bump. Yeah. Now, question 2. Do I have or need a statute of frauds writing?
Yes, usually yes, but
Not in that case. Why do I not need a statute of frauds writing?
because they were so verbose about announcing the contract, basically, right?
Why do I need a statute of frauds? Erase your mind from question 1 of formation. Erase it. What do you need? First of all, do I need a statute of frauds writing?
No.
No, I do not. Why?
Because, well, I think in that case they had on video, they shook hands on.
You guys are still doing formation. Yeah, it was a company. This wasn't a sale for over $500, so 2201 doesn't trigger, and it's not land, right? And it's not a contract that stands surety for the debt of another, and it's not, what would be the last category that I would check for?
Like a contract that can't be performed in under a year.
A contract that can't be performed by its terms in under a year, which I would go looking for in that particular case, given that in Arnold Palmer, they'd already acquired that other company and gone into a joint venture together. And like, I would just be astounded if somebody hadn't said, yes, this partnership is going to last for X period of years, right? Like, I would sort of check that on Midwest versus Orion. So there's at least an argument that you do need a writing, which means I'm going to now get to part 2, and this is why the statute of frauds really wasn't part of the Arnold Palmer case. It was a formation case, not a formalization case. But what I'm doing is I'm showing you how these different questions come in or out of your mind as you're moving through the case. Also, let's say you did, let's assume you did, although I think the basic answer is you don't, is at least as a first cut, right? Handshake deals to sell companies, perfectly valid. But let's say that, which by the way then gets us back to the handshake being okay if you didn't need a statute of frauds writing. Everybody see that? Now, let's say you, however, do need a statute of frauds writing, largely because we discover some term saying that by its terms it cannot be performed in under a year. Let's say that they say this partnership shall extend to 5 years, right? So we find that term. We now need a writing. What do we do in Arnold Palmer? Well, that's because that's always going to be our place to go if we can't get that. Tell me how reliance is going to work for that particular question of do we need a writing? Yes, we argue we do need a writing. What's reliance going to do in this case?
It's to get past the statute.
Yeah, and what case are you going to rely on for that? You've given a brilliant answer, so I apologize for pressing you on it. Double A, but I would do, double A builders used reliance to supply what? What was missing from the double A contract? Consideration was missing from the double A contract. What are you trying to supply that's missing from this contract? Statute of frauds. What case says we get to add the statute of frauds?
Midwest versus Rhode.
Midwest? Nope. Because Midwest said, remember, there wasn't a statute of frauds thing. They just, well, kind of, fair enough. What they did there was they said there's no statute of frauds writing because the contract by its terms was for a number of years, right? They then enforced or quasi-enforced the contract, but they only did it as a matter of detrimental reliance, right? That is, what they were doing was true Section 90, getting the out-of-pocket costs for the franchise space, right? What they weren't doing was saying, oh, there's a contract, we saw that it was formed, we know we need a writing, we don't have one, but we're going to take reliance to supply the writing. And we do have a case that does that. Yep. B&W Glass, one of my least favorite cases of all time, that does exactly what Talia is suggesting, right? What it does is it does something very different from Midwest, and this is an advanced point, and I would love it if I could communicate it clearly. Because what B&W Glass did was say there was an underlying contract, that it existed, there was no writing, but we're going to supply the writing we need. And so what B&W Glass does is it enforces it as a contract. Do you see that? It doesn't do what Midwest did, which is roll with the theory of promissory estoppel, saying you get detrimental reliance damages, your out-of-pocket damages. BW says you get it as a contract. You get contract damages. There was a problem with enforcing that contract. You had a contract, you didn't have a writing, so there was a problem with enforcing that contract. We will remove that obstacle. Now, you had a contract. We need a writing. Yes, we do. But we're going to remove that obstacle to enforcing the contract. We're therefore going to enforce the contract through. That is a very different outcome, and that's one of the reasons why I'm so infuriated by it. You know, Midwest is an okay case. Like, I get it, and the guy was kind of a jerk, and they enforced detrimental reliance, and at least what they didn't do was they didn't force the parties into a contract they never signed. You notice that? They still didn't force them into a contract they never signed. They just made the jerk pay for the out-of-pocket costs that the non-jerk suffered. That didn't put them in the same position they would have been in if the contract had been carried out. It put them in the position as if the contract had never been made. You see that? That's a real difference. That's why B&W Glass makes my teeth itch, because you're tying people who never signed a contract to a contract, not to detrimental reliance for being jerks, but to a full-on contract. All right, valid answer. I didn't want to move past it, but not what I was looking for in Arnold Palmer. In Arnold Palmer, why don't we have a statute of frauds problem, Scott?
Don't they just look to the letter of intent?
Yeah, because they have a writing. Remember, Midgerobe is your friend. Certina is your friend. Almost anything can be stapled together to get you that writing, especially in the common law. Hell, you don't need much at all. You just need some sense that the parties entered into the agreement and then signed by the party to be charged. Great. They signed that letter of intent. We have a writing. That's the reason it's not an issue in the case, because we actually have a writing in the case. All right. What we've done there is used Arnold Palmer as a way of describing how these three separate questions pop in and out of your thinking. Again, I encourage you as a discipline, each time you go through one of these things, consider the questions one at a time, completely erase your thinking before you move on to the next question, even if they begin to overlap and confuse you. Say, no. I am no longer trying to figure out, I'm not yet trying to figure out what the terms of the contract are. I'm just asking if there's a piece of paper with somebody's writing, with somebody's signature on it. That's all I'm asking, right? Or I'm not asking whether or not the contract was formed or not. I'm just asking whether it was a piece of paper with somebody's signature on it. Or, okay, I know I've got a piece of paper with somebody's signature on it, but the parties here are claiming they never talked to each other before in their lives. So formation first. Looks like there wasn't a contract here. I know I have a statute of frauds writing. That's not the issue here. That's Professor Fairfield telling me not to engage with that part of the question because there's a signed statute of frauds writing. What I need to know is, did they ever agree on a contract? And I'm going to look over here.
But even if you staple those papers together, can you still argue that it was a Fred who had signed maybe one of those papers?
Oh, absolutely, right. It's got to be signed by the party to be charged, right? And that's subject to fretting all day long.
And that's like a TVA that goes back to the
Yeah, absolutely. That's right. That is absolutely, if the wrong person signed it, when you're trying to staple things together, right, you're not going to be able to go and get, you're not going to be able to go and get a Fred to sign it. It needs to be signed by someone who has contract authority for the company. Great question. Valeria.
So when you're stapling the different writings together,
Yes.
do each of them have to have a signature?
No. And that's the dangerous part. Because if you look at that hard enough, you go back and reread that case and then think about the blizzard of paperwork that exists within any modern corporation and be like, well, I can find 3 different pieces of paper and I can staple somebody's signature to it all day long. How do you avoid that? The court's going to need the documents in some way to persuasively hang together. Right? What was going on in that case was there was the watch list that kind of gave you the what of the contract, what was being sold. And then there was another thing that had the signature, but they all seemed to relate to the same transaction. And the court, felt legitimized to staple them together. To be clear, that's a lever pull on the attorney's part, right? They're playing games with, oh yeah, these are totally clearly about the same transaction, because you can always go find 3 pieces of paper and say, I'm going to staple them together. The question is, can you convince the court that that's a legitimate move? Lucas.
In a case like Palmer, where they clearly had a handshake and said we're going through with this deal,
Yep.
how essential is the statute of frauds writing that there's the judicial admittance, loss of that defense?
Okay, so first of all, remember that the handshake on camera has a couple of different meanings. 1, it may just mean contract formation. Great. 2, it may serve if you can get a court to say, oh, this is a record that the parties have adopted with the intent of acting as a memorialization of their terms. You might get them to treat the recording as the statute of frauds writing. Right? Maybe. That happens a fair amount in text orders or stock orders using instant chat. That's how that fact pattern starts showing up on the bar exam. But then I guess the third part of it is if the court says, yes, this is formation, but no, it's not a statute of frauds question, then you're left. Does that answer your question? Because then that leaves you with, well, I need some document, and that's where they're going to turn to the letter of intent.
So is it just kind of like that when they have the video of the handshake, they don't actually have the terms of the contract in front of them, so they don't really know what the handshake's about?
Yeah, remember the court doesn't need, if it really knows its law, the court doesn't need the statute of frauds writing to have all of the terms set forth in it. You may have a problem if you are trying to enforce a term that is not in your statute of frauds writing, and if the court treats the statute of frauds writing as a, third question now, final written agreement between the parties. Now, maybe in your jurisdiction, video falls under written. I wish I could make this stuff up. but I don't. Like it counts in many jurisdictions. So maybe you can convince them that it was a written agreement. You probably can't convince them that the fist bump alone was a final written agreement. Among other things, apparently they had binders that were kind of empty, and they were showing the binders around and during the press conference and shaking hands and stuff. So it doesn't look like the contents of the contract were on display as part of that if you were trying to treat the recording as a writing. But what I need you to see is how that moment has three completely different meanings, right? Meaning one, fist bump, that's offer, acceptance, and consideration. Boom, right? Okay. Question two, is there a writing? I don't know. Does your jurisdiction treat electronic records? By the way, the place that courts are going to press down on that is, did the parties intend to adopt this thing as a signification of their agreement? Was the email signature at the bottom of my signature just an identification of who sent the email? Or did I intend to say, yeah, this is our deal, signed Josh, right? At which point that begins to look more like we adopted the record with intent. And this is especially true under the Uniform Commercial Code, which sort of blows up the idea of a writing and turns it into text messages or recordings or voice messages and stuff like that. But then the third part of it is, what terms do we prove? And that's a completely different question. How would you do that? Well, among other things, you'd say, gee, do we have a final written agreement? We have an agreement, I know, but is there any writing or record that is a final written agreement that's going to get in the way of adding terms? By this point in Arnold Palmer, I'm going to just say no. Like the letter of intent, even if you took the letter of intent as our key document, it still had gaps you could drive a truck through. That was the point of the lawsuit, right? So it's clearly not a final. Oh, by the way, there's another reason why it's not the final written agreement. Can anybody just say, hey, Fairfield, why are you wasting our time asking whether it was a final written agreement in Arnold Palmer? Yeah, because it was like expressly saying there's gonna be a final written agreement that we write up. Like they said, we agree, even if you took the court's holding in Arnold Palmer seriously. They said, oh yeah, you guys agreed. We just know you left some pretty key things open to agree on later. It wasn't an agreement to agree, said the court, because they did kick it back to the jury. Right. But they did say it certainly wasn't a completed, final, done deal written agreement. They just said it was an agreement that you left some holes in, and you agreed to sort those holes out later. And so there, it's very, very hard to say any part of that process is a final written agreement, which means that you're going to have a pretty damn easy time proving those negotiations as terms past the parole evidence rule. Do you see that? You don't have a final written agreement. The parole evidence rule is not really going to get in your way in terms of adding evidence, putting people on the stand, talking about what they were doing and saying in that airport conference room in Tuscaloosa or wherever they hammered this deal out, right? As the napkins were flying back and forth and people were just, like writing all this stuff down. You're probably going to be able to bring in most of that testimony, put those people on the stand and have them testify as to what they actually intended, because you'll be able to add those terms to the sketched out terms in that letter of intent, clearly, and you'll absolutely be able to add those terms if the court takes the recording as the relevant text, because that had basically nothing but a fist bump and a bunch of empty binders. And so there's nothing in that text that's going to block parole evidence, extrinsic evidence as to what the parties actually agreed.
Because the handshake occurred before the discussions like that were ongoing, so that is anything after the agreement is...
Well, let me just ask you back, because you're the court for a split second. Are you considering the recording or the letter of intent to be your relevant document for purposes of the parole evidence rule?
In this case, I'm considering the handshake recording.
Okay, so assuming then that there is no letter of intent, let's just take that out of the picture for a second. Let's assume there was no letter of intent. The parties are just busy shaking hands on TV, right? At which point I'm going to say, yeah, it doesn't matter whether it was prior or after. That is not, the parties did have an agreement, formation, but they didn't have that handshake ceremony was not a final written agreement, and so therefore it doesn't serve to bar extrinsic evidence of what the parties did during the negotiation. Like, fine, you could say those negotiations happened before that. Hell, if you wanted to get them out from under the parole evidence rule, you could say those negotiations continued on after, and anything that continued on after obviously isn't incorporated under the parole evidence rule because the parole evidence rule only blocks things that are before that final written agreement. But in either case, that handshake was so content-free that it's not going to block any evidence, any contradictory or supplemental or other oral evidence about what you said in those conference rooms. Yeah.
So if you can prove that the original letter of intent was intended to be the final agreement,
Yep.
and then you have this handshake ceremony later on, but maybe there is some different terms in that handshake, what do you do with these different terms? Like, if you intended...
Do you want them in or not?
No, I don't want them.
Okay, you don't want them in. Then, how is Liam going to keep them out? This is a perfect example. That's called an exam question.
If the original contract was written for statute of frauds, then all changes have to also be written.
So one, you're going to look for any changes having to be written in the statute of frauds. Every chance that they're not, because the parties didn't, in Arnold Palmer, at the time, didn't really think of that as a completed agreement. They left gaps in it, and they knew they left gaps in it, right? So what's another thing that you might try to do? Yeah.
You should say tomato to their tomatoes.
Right. So, one, you could try to just say, we disagree. Although remember, the knockout rule is for the Uniform Commercial Code. Here we are buying a business. So the knockout rule of the Uniform Commercial Code doesn't apply, one. And two, well, we'll just stick with that. So the knockout rule of the Uniform Commercial Code doesn't apply, although if it's a UCC contract, absolutely, you're looking for tomato, knock these things out. Remember, 22072 is not just a rule of contract formation, that's 22071, but is a rule of contract terms determination, 22072. So that would work if you were under the UCC. I mean, I think the only other, go ahead, yeah.
So then can you just say it was just simply a counteroffer that was agreed upon?
Well, you could say it was a counteroffer that wasn't agreed upon, but under our facts of the case, the judge has already, if I understood your hypo correctly, the judge has already determined that the letter of intent at time one did count as offer, acceptance, and consideration. So we're no longer playing, is there a contract game, right? That's why I'm telling you to don't cross the streams. Answer the question first, is there a contract? Yeah? Cool. Erase it from your mind. Note that down and erase it from your mind. You are dealing with other things. The only other thing I could think of to do, and it's not going to work, is if you had the deal in the letter of intent, part one, and then you have terms after the fact that are going to come in, and they are going to come in unless you have this lockout clause saying we've got, right, unless we have this lockout clause saying that all modifications of the letter of intent have to be in writing. If we don't have that, then these are going to come in because the parole evidence rule will only apply to stuff that happens before your writing, right? The only thing I could think of to do is to try to take the later event and make it useful statute of frauds wise, right? Something like saying, this later fist bump event, that is a record, maybe we can argue that in this jurisdiction. This is advanced stuff to say that the recording is a written agreement and that we, by that point, negotiated out of all of the final terms. And what we're going to do is block the stuff in between because the later event is supposed to stand as a bar to the stuff in between. You find a later event and call that your new statute of frauds moment so that it blocks anything that came prior to it, right? Because you can always say, oh yeah, we had these later negotiations. Well, that's cool because I've got an even later writing that blocks those negotiations. See how that works? It's a rough row to hoe in this case. You'd need more than a fist bump on TV. That fist bump would need content that you would then say these interim negotiations contradict that content, and so you can't bring in evidence to the contrary into court if you want to keep that locked out. Okay? Love it. These are really sophisticated, sort of kind of final boss level questions. This is good stuff.
Just to put a cap on Arnold Palmer,
Yep.
could you at all like appeal to 1303 and like say that like the handshake was like a usage of trade?
Okay. There's a bunch of answers to that. One is we're not using the UCC in Arnold Palmer because it's a business, not goods. And you're right, though you're pointing to 1303, right? The first number of that sequence isn't a 2, it's a 1. And so that applies to the whole range of Uniform Commercial Code. But I am here to tell you that in Articles 1 through 12, there is not a selling the business part of the Uniform Commercial Code. There are rental of goods, sale of goods, and a few other articles there. But we're still not formally under the UCC. All right, so now so far we're in a 1L contracts class. If we go to a 2L or 3L or practice contracts question, yeah, sometimes you can bring in precedent and arguments that allow you to use 1303, industry, custom and practice, course of dealing to give meaning to terms outside of the UCC. If you want an argument to do that, take a look at the earlier provisions in Article 1 that say, and we saw this in BW Glass, go reread it, if the UCC states something different from the common law, it blocks and replaces the common law. But if it doesn't, you are free to, and in fact are encouraged to, use UCC principles to help us understand common law cases. There's at least one case that we've seen where the court straight up does that. That's the predecessor case to our infamous Hill versus Gateway. It's Easterbrook's decision in Pro CD versus Zeidenberg, where Easterbrook just straight up says, this is a case about software. Software is not a movable good, but I'm going to use the principles of the UCC anyway. And that, in fact, remains the case for CDs and USB keys and boxes that you buy at Best Buy, even if they've got download codes. We, to this day, still do use the Uniform Commercial Code. So I don't want to just say, the easy answer is, no, you can't use 1303 because this is a buying a company case under the common law. This is not a UCC case.
You can appeal to it.
That is true. You can still, however, appeal to the UCC if it doesn't expressly contradict the common law. And it's pretty common, as we saw in a bunch of cases, it's pretty common to have reference to the industry, custom and practice, and community to give meaning to, and this is my final point, to give meaning to what? What is 1303 about? Which of our three questions is it about? Because I don't want to pick on you, but you formed it as this is a contract formation question. Did the contract exist? Your specific issue was, does the fist bump form a contract as a matter of industry, custom, and practice? Because our industry is used to forming contracts with fist bumps, right? But there's a narrower issue here. Where does custom and practice, course of performance, course of dealing, which question of our first three does it relate to? Yeah, Bill. Interpretation of the terms. And so you're going to have to do a little bit even more lifting to say, wait a minute, I'm not going to use it to give meaning to the words of the party's contract. I'm going to have to use it to give meaning to the party's conduct in forming a contract. Now, I'd take money to do that. And to the extent you're interested, we are now in full-on practice. Go look at the 1201 definition of an agreement under the UCC. An agreement is considered to be more than the contract. And so you can say our behavior in forming the contract, we might be able to draw on sources like 1303. Generally speaking, though, it's going to be a heavy lift, and it's going to be a multi-stage, very heavy lift. All right? Yeah.
So the test we talked about, is it a contract you have a writing and then you get around the full evidence?
Yep.
That's just general tools we can use when analyzing.
Yes. That is question one. Is there a contract? Was there offer, acceptance, and consideration? Question two, do I need a statute of frauds writing? If I need a statute of frauds writing, do I have one? If I don't have one, can I find an exception? That's second question, formalization. Third question, interpretation. What do the words mean in light of industry, custom, and practice, in light of the context and the community that you are identifying to give the words meaning? Are you blocked out? Is the contract partially or fully integrated for purposes of the common law, which I think is lame? Or is the contract a final written agreement that has an integration or merger clause under the UCC? Those are the relevant things. They're getting to the same legal points, but those are your two more broad set of paths. And that's how you get your information past the writing if you need to prove it in court. All right. Anything else, y'all? Okay, let's move into these cases. We're going to move through them fairly brusquely because at least a number of them are just here to tell you what the common law is, sorry, what the UCC is and what it looks like. And the good faith cases, at least, we've seen before. Kiana, would you be willing to take on Haynes versus City of New York?
Sure. So the backstory is that the City of New York and the two townships agreed on a contract to construct and run a water treatment plant to prevent discharge of untreated sewage by residents. The township had agreed to bear the cost of extending the sewer lines a few years after that, and then over time, the plant was operating in excess of its capacity, and additional use would result in inadequate treatment. And so Haynes, a developer, 50 residential lots, brings a contract action as a third-party beneficiary against the City of New York, and he wanted to connect the sewer lines to these residential lots that he was developing. The city refused, saying that it was not obligated to expand, and the original contract was for an indefinite duration, but as we then find out, because of this case, the court can supply a reasonable time to a contract that doesn't have a definite duration, and so it ruled that it was not obligated to expand the facilities, but it had to continue the contract. It couldn't just exit the contract at will.
Great. All right. We've got a contract. What's the indefinite term? We're talking about gap filling here. What's the indefinite term?
The indefinite.
What term did they leave out?
The timing of the contract.
The timing of the contract. Have we seen that in every damn long-term contract before? Yeah. Timing plus uncertainty just leads to a sun printing problem. And color me absolutely shocked that this turns out to be the issue in a long-term contract. Don't be these attorneys, right? Bad move. Fine, we'll get to the resolution in a second. It's not complicated. Well, no, let's just do it. Let's just do the resolution. What's the black letter law that we're looking at here?
It's that basically a contract without an express duration, if a contract doesn't have an express duration, the court will imply the intended reasonable amount of time. And this is restatement 204, supplying an omitted essential change.
Nail it. That's the black letter law. If the parties have reached an agreement, what part of the class is that? Formation. If the parties have reached an agreement, but they've left something out, and remember, sun printing, there's lots of arguments that by leaving something important out, they never had an agreement. Why is that just not going to be a question in this case? They left out the duration term, like they did in sun printing. Why don't we just say they never had an agreement?
Performance?
Yeah, because they've been doing this for how freaking, like they built the plant. They've been expanding capacity. We're past that now. Neither party is interested in saying, oh, there's no deal. Like that's crazy, all right? So now we're saying there is an agreement. They left something out. The black letter law is not hard at all. That's restatement 204. When you do that, when there is an agreement and the parties leave something out, the court will supply a reasonable term. And it's not just a reasonable duration, although boy, is that ever one of the most common ones, right? See sun printing, see everything else. But it's any term that gets left out, the court is going to try to supply a reasonable term. Cool. The court's got a choice of terms. Note, I just want you to pay attention to how the court constructs itself as reasonable. Do you notice how it does it? It immediately makes up two completely unreasonable positions and is like, both sides suck. So what are the two unreasonable positions that the court's like, nah?
The at will.
Right, so the City of New York says,
They say that their contract was at will, and the court is like, no, it's not, because you were saying that you're going to take over.
Right.
While the water needs to be used, you need to continue this contract. And then the other term was,
And then the other argument was, what did Haynes say?
Haynes was saying that it was perpetual.
Yeah, right, that like I could just grow into the greater metropolitan, like, you know, that Judge Dredd city, like Megalopolis or whatever the hell, right? So we're just gonna build our little suburb into like, you know, the megalopolis, and New York's on the dime for all of the water needs in perpetuity and no matter how far we expand. And the court's like, well, that's not reasonable. And then the court's like, and now my name is King Solomon and I'm going to say, and what's the court's reasonable deal?
The course, is that it did not have an intention to cover this land because it wouldn't have never expected to serve these residential lots.
And so what's the court's ruling? Saying it doesn't have to expand to this subdivision.
Yeah, it's not obligated.
Is not obligated, but they do have to keep the water coming to the town. They don't have to, and it's literally, you know, splitting, it's literally Solomonic, right? Saying, okay, you get something, I don't know, I'm going golfing. And so the court just sets up two extremes, puts itself in the middle as reasonable. I don't want you to say like, oh, that's reasonable or unreasonable as a matter of law. I just want you to watch how the court pulls that particular maneuver. All right, we know the case, we know what's going on in it, we've got the black letter law, nailing it. The hell is this guy Haynes? What the hell is he doing in this case?
I mean, I guess he's trying to just get someone else to pay for what he's trying to do.
Well, no, but I get that, but like, if you and I have a contract to buy my car, what I'm trying to figure out is like, how anybody else in the class is suing us based on that.
Well, he's a third party.
You know, I get that, and so are they. And they're like, we don't want to hear the F-150 that can't move metaphor anymore. So we would really prefer to enforce that contract to go through between the two of you. They're third-party benefit. Remember what a contract is? A contract is a pocket universe between, and I know this is crazy, the people who signed the damn thing. Who ordered this guy for lunch? Yeah, I think it's a major driver of the case. I'm going to give you a practice tip also. Every once in a while it shows up on my exam. As attorneys, your overwhelming drafting goal is to make sure there are no third-party beneficiaries to your contracts. I'll give you an example. I fairly routinely, because I did a lot of work in virtual worlds and then later on in crypto and where digital assets earned a lot of money, I would pretty regularly get calls saying, hey, I've been playing this game or doing this crypto project, and I notice somebody else in the game or the crypto project is breaking the rules of the game or the crypto project. And they agreed in their end user license agreement to not cheat or to not conduct an infinite mint attack on my crypto project. They agreed not to do that. So I would like to sue them. And the answer is, yeah, but they promised, but they didn't promise you. They promised the game company or the crypto foundation. They promised, but they didn't promise you. And then, as assuming that those relevant end user license agreement were drafted by somebody who can find their ass with both hands, which I know is like unfortunately too commonly a question, that will have a no third-party beneficiaries clause. If you are a company, the last thing you want to have legal relationships locked up with your customers. You do not want your customers suing each other. Unless you do. Ask me if you're interested in building one of these aggressive crypto foundations that does not want to be in charge of its project because they're worried that they'll get regulated, and so they want to hand that off to their community, and they want their community to have binding legal relationships with each other. Talk to me after class if you're interested in building that. I've seen that happen more than once. But otherwise, your job is to keep third-party beneficiaries out of this. All right. When do third-party beneficiaries come in? Also part of your practice. You should be aware of this. Here's your core third-party beneficiary example. If you write a will and you screw it up, you may expect the beneficiaries of that will to sue you. Your contract was with your client. The beneficiary, though, is literally the beneficiary. And so you can fully expect them to come knocking as the beneficiary of the attorney's services contract that you entered into. All right? That's just an example of where it does come. But what I want you to know is just as a practice tip on my exam, I've done it a couple of times as one of my client counseling questions. A couple of times I'll say, hey, a client comes in, they say they want this. And you're like, no, you do that, you're going to get third-party beneficiaries. Your customers are going to be suing each other. You don't want to do that. That's where that kind of question pops up. That's what this guy's doing in the case. Notice how he gets treated, even though there's a theoretical possibility. And like, you can see the point, right? What's the point of saying you can sue as a third-party beneficiary under New York's contract with this town to supply water? Yeah.
You're expanding the town.
Well, you're expanding the town, which is why he was doing it. And that's why he got told no, right? But what's the argument that like a member of the town should be able to sue?
Because they pay for the water from the company.
Yeah, because they pay for the water for the company, Bailey.
I was just gonna say it's public policy, you need to keep it in check.
Yeah, that is, you're the beneficiary, you're the one getting the water, right? You're literally the person who can no longer survive because you don't have clean water. They entered into the contract on your behalf. Now, they didn't enter into the contract on this dude's behalf. He wasn't the one getting the water at that time. But you can imagine it's not an insane argument if you're already drawing water from the city and then the city starts like polluting the water, New York starts like poisoning the water or something, and you sue saying, no, wait, I am, like when the town entered into the contract with New York, they were doing it on my behalf. You can see the argument, right? But this guy, he's a step too far, so the court doesn't really take him seriously. To me, that's the most important fact in the case. It's not just 204 supplying a reasonable term. It's why the court is doing what it's doing. And it's doing this saying, you're a developer. You bought this land knowing it wasn't supplied with water, and now you're trying to dump that on the taxpayers. Not a chance. That's what's going on in the background. Okay. Any questions about Haynes before we move on? Yeah, go for it.
Onto the practical thing of like how does, because in its reasoning on 352, they talk about how the court says that the city can get out when it no longer needs or desires the water, but then says they can't use environmental law to get out because they didn't foresee it at making the contract. Like, how do you practically, how does a city or someone get out of that type of contract if you have this somehow prove it was foreseen?
Yeah, I mean, it's the same kind of argument we've been making all along. There are two opposite and equally valid arguments. The one is, this was a really big deal. If the parties had, this was a really big deal. If the parties had thought about it, they clearly would have resolved it. And the flip side of that is also true. This is a really big deal. The parties chose not to resolve it, so their silence on the question indicates that they thought about it and chose not to make that part of their discussion. Which is right, I don't know who's paying me. All right. What I need you to see is the two opposite arguments. Okay, cool. Let's move on then to Genecom 204. We're moving from 204 restatement to 205 restatement, and that's Centronics. Leland, if you wouldn't mind setting up Centronics for me, please.
Sure. So, Genecom is purchasing Centronics business assets, and they have a very detailed contract that they're working through that involves working through an arbitrator for any disputes. They have a certain amount, it was $5 million that was placed in escrow, and the arbitration just winds up getting dragged out. Centronics complains, they say, hey, we need this money from escrow, it's not in dispute, we need it for a business opportunity. Genecom says, no, that's not what our contract is, I'm gonna wait until this arbitrator gets this done and we'll follow what we agreed to. And so Centronics sues, saying that Genecom's not acting in good faith, and court says, you can't just write a shitty contract and then complain that you're not getting the results that you wanted. Write a better contract next time.
Which turns out to be most of what the thing is saying. And in particular, not just write a better contract next time, but also it's not clear that either party is the good guy here. What's the argument that Centronics is actually, they're the ones that have caused this dispute to drag on by...
They both have like essentially their own option, their own time period that they can delay everything for disputes. They both have like 30-day periods where they're responsible for it.
They have 30-day periods. And also, why is there such a huge fight over this?
Because the price was left open, Centronics is incentivized to try to ask for as much money as possible.
And they did.
And they asked for the absolute cap, and they're not moving on it, but they just want to have their cake and eat it too.
Right, so they introduced all this uncertainty by saying, look, the parties put this money into escrow because they weren't sure how much the full price of the company was going to end up being, right? And then they said this is going to be subject to arbitration, but then Centronics comes in and blows that number way up. Of course, the other side's going to fight this all the way. And why would you say that they have to have an obligation to end the arbitration early when you're the ones that have injected all this chaos into it by making this outrageous claim for the price of your business? And so the court is not just saying, hey, you wrote a crappy contract, you can't get out of it. The court's also saying, you acted in a crappy manner under your crappy contract. You don't get, and I love this phrasing, you don't get to have your cake and eat it too, right? Yeah.
Hilariously, they caused that issue, but then they're also blaming Genicom, saying,
Yep.
well, they're just trying to play a waiting game. That way they can
Right.
get us to negotiate down. And it's like, dude, that's negotiation.
Right, that's,
But it's also
yeah,
direct outcome of you guys trying to wait.
you're forcing my foot to be in this bear trap that I sprang on my foot. Ow, let me out. You're like, dude, it's your bear trap. You're the one that stuck your foot in there. Why are you complaining? Okay, that's mostly what disposes of the case. Let's make sure we've got the black letter law nailed down, and then there's a few things we need to know. What's the black letter law of the case?
Essentially, that discretion is required to be able to execute bad faith. And so they're saying that to accuse somebody of participating in a contract in bad faith, they have to have some sort of power that is withholding you from receiving the benefit of the contract. In this case, Genicom doesn't have that power. Everything's up to the arbitrator. There's set time periods.
Okay, that's the correct answer. So I'm going to step back a little bit, but I want everybody to understand that's where we were going, and that's the answer. All right, now let's just back up a little bit. Restatement-wise, where are we?
It's from Restatement Second of Contracts 205.
205, and what does it say? Although it does not give the answer you just gave, which is the right answer. This is an intermediate step. And it's not particularly interesting.
Thank you. Okay, so duty of good faith and fair dealing, it's defining the meaning of good faith and then
Yeah.
saying that, let me see.
Now, if you're looking for the meaning of good faith, good luck, right? It's not in there. It's just 205 saying there is an obligation of good faith implied in every contract. That's where we are. Remember, we're talking about terms, and these are the invisible terms. And all we're saying is what you already knew, which is in every contract, there is an invisible term which says the parties have to carry it out, not negotiate it, execute it in good faith. But it doesn't give any meaning really to what good faith means. And so then we have this fight between Summers and Burton that get, Professor Summers and Burton that get referenced in this case. What's Burton's view of this stuff?
That it was the
What's good faith mean to Burton?
use of discretion. It's
The use of discretion, and that,
the 4 points of like, does this party have discretion in the performance of the contract? Do they use that discretion? Is their intent unreasonable? And does that unreasonableness then damage the
Right.
other party?
yeah, perfect. That's the operating rule. Where does that analysis come from, that a party can't have discretion in a contract that it can just use anytime it wants to deprive the other party of the benefit of their bargain? Where have we heard that before, Talia? Yeah, like I get it. It's another one of these examples of illusoriness everywhere. No court's really going to call that illusory, but you're absolutely right. Like imagine if they did have that unfettered discretion to change something under the contract and screw the other party out of the benefit of their bargain. If they had that discretion, we would actually start seeing that problem all the way back in the beginning of the class. It's going to come through in each of our phases. I just want you to point out that this is another example where the court sees a hidden heads I win, tails you lose, and avoids it by saying, but no, you have to exercise this discretion in good faith, which we've said about 1 billion times so far, right? Why aren't requirements contracts void for lack of consideration? Because you have to establish, and that's one of the follow-up cases, right, in one of the note cases, where Posner says, you have to make your order in good faith. You have to state your requirements in good faith. So this is all, in some ways, this is just the same stuff we've been doing over and over again. It's just displaced into a different question in the course. Here we're talking about terms. Before we were talking about formation. But it's still the same thing. The court detects that free option. Here doesn't void the contract because there's a hidden free option. It just says there will be no free option today. Now, never mind the fact that the court's saying that Genecom didn't do anything wrong in bad faith. There's more. Under the Burton standard, it blocks the good faith analysis at what step?
The first step.
The first step, right? It nails it right off.
The discretion to be able to impact this.
They can't tell the arbitrator to release the funds early, and so in some senses, this is the stupidest case anybody's ever seen. They're asking them to do something they can't. They literally don't have the power to ask the arbitrator to release the funds early, and the arbitration's dragging on because you geniuses asked for a lot more money. And the other side obviously has something to say about that. Not a hard case. We're not here for the facts of Genecom. They were idiots. We are here for the Summers and Burton analysis of what good faith is. We know that Restatement 205 puts that implied obligation of good faith into every contract. For the content of those words, what good faith means to our community, to our context as lawyers, is defined by Summers and Burton. One final question, what's the Summers view? Burton's view is this unfettered discretion crap. Not crap, that is the test. That's actually a smart test. And you've done a fantastic job. If you want to call co-counsel, feel free, but otherwise I'm going to let you take a crack at it.
I am going to wait. Yeah, I'm co-counsel.
Okay, Kat, go for it.
The obligation of good faith performance is better than excluding behavior inconsistent with common standards of decency, fairness, and reasonableness, and with the parties agreed upon for grounds of justified expectation.
Okay, so the idea here is that in the area, in that context and community, these are common standards of decency. Notice that the one says one party had discretion and then were acting badly using that discretion. That's standard one under Burton, and that's what they choose in this case. The other standard is saying, hey, this community has it's a community analysis. By each community or industry, they have these standards of what is good faith and what's bad faith, and so we'll apply those. What's the difference between these two standards, and where have we seen that before? Go for it.
Is it Eastern Airlines?
Yeah, we've definitely seen it in Eastern Airlines before. We had the same conversation before. And what did I say was the definition of good faith in Eastern Airlines? As long as we were being incredibly precise, because that's a very good catch.
I was going to say, I thought I saw something else, hand go up. But isn't just acting in accordance with the industry custom practices
That's
violating?
Eastern Airlines is a case drawn from what area of law? UCC, because gas is movable, because jet fuel is movable, right? And you said half of it. This is 1201, the definition sections of the Uniform Commercial Code, and it is 1201's definition of good faith. And you're right, it does say the observance of good faith.
Isn't it like
Honesty in fact, and the observance of good faith, and the observance of the usages in the industry. Now, I'm going to ask again, because that is, do you see it right there? That's the Summers is the observance of industry best practices, and Burton is the honesty in fact, right? And what's that divide?
Is that common law? The Burton is more common law because discretionary clauses like board clause or lawyer.
I mean, maybe. It certainly is clearer under the UCC, because the UCC lays it out, but there's a decision here. Jake, yeah? It's objective versus subjective all over again. Which one of these, Summers or Burton, is our objective? Objective. Right, go for it.
The commercial standards?
Yeah, the observance of general commercial standards. That's going to be Summers, right? The idea that we've got these overarching rules. This is the list that Kat read out, right? These overarching rules. And then Burton, right? He's the one saying you've got this specific discretion and you're doing something bad with it that's denying the other party. That maybe tracks, although it's also kind of objective, right? That's also because it's written in the contract at least, right? But that at least the idea there is, and we'll see in the next case, they're using something that they were allowed to do with bad intent. And in the next case, we'll see how that works out under the UCC, less clearly than I would like, given the fact that we've just finally made it clear. What I want to do is just draw the line here. 205 says there's good faith. We have to give meaning to the words good faith. Unsurprisingly, the meanings are exactly what Jake said: subjective and objective, honesty, what Lucas pointed out, honesty in fact, that's subjective, and observances of the usages of good faith in your industry, that's objective. We can draw the line there between theory, right, some subjective and objective, to common law, Summers and Burton, to 1201 and the definition of good faith under the Uniform Commercial Code, which tries to capture the same thing. And that's going to help us understand what's going to happen in an upcoming case, which is otherwise just a complete disaster unless we've got this clear. Yeah.
So, upcoming cases, 2305, that would fall under Burton's subjective theory more or less?
Well, as long as we're jumping that particular, as long as we're jumping that, let's move to it. But the answer is, what standard of good faith are we going to use for a case covering 2305?
Industry practice.
2305. That number 2305 means what?
Reasonable and non-discriminatory.
What law are we drawing on? I'm being even more of a dork than that. I'm being super pedantic. It's UCC. So if we need to know what good faith means under 2305, where do we look? 1201. I'm going to read it out to you. 1201, and in particular, it is 1201B20. And this is what Lucas said. I'm just going to say it again because this will be the law we will be using. Good faith means honesty in fact and the observance of reasonable commercial standards of fair dealing. We're not going to reference Burton and Summers. That's more common law. We're going to reference 1201B20 and its statutory grabbing of that subjective bucket and objective bucket through the statute itself. All right? Cool. Let's move then on to that, because this is in fact Shell Oil, and we've already done some chunks of it, but let's see what we got. In fact, Jake, since you nailed that subjective versus objective point, would you mind setting up Shell Oil for me, please?
Yeah, so Shell Oil is basically a bunch of dealers like Shell stations suing Shell for having their price too high. They say that the DTW, the dealer tank wagon, is unfair, and they're basically saying that under the subjective view of honesty in fact, that Shell is not acting in good faith because they're pricing it too high. Shell counters saying that it's within reasonable market prices, and so using the objective view of common practice, then they're not acting in bad faith.
Yeah, I mean, no notes. Like that's absolutely right. Okay, why is this a perfect case? Let's just back up a second. What law are we applying? UCC, right? And the relevant provision is 1201, which is giving meaning to good faith. What's the discretion involved? The price that they're setting. What statute lets them set that price? 2305. Okay, now we know exactly where we are and exactly what we're looking at. You can set the price under 2305. We can leave price terms open, Judge Cardozo, Sun Printing, right? We can leave price terms open under the UCC. We can do that all day long. And we don't even need to have the court set a reasonable term. We can just leave it up to one of the parties to set a reasonable price term, which is one of the reasons why I told you, right? So Shell Oil is the reason I told you sun printing never comes out the way it did in sun printing, right? Like you could actually just leave the price term open, leave the time open. It's okay. The court's just gonna be like reasonableness everywhere. And we're just gonna fill all these gaps, and we can even let the parties fill it in as long as the parties act reasonably. And that's the whole backdrop of this. But then, Jake, to your point, to your very specific point, what's going on where the parties are saying, where the dealers are saying, okay, clearly, this is in subjective bad faith. And they're right.
The dealers are saying that Shell is pricing the DTW price too high because they want to force them out of business and have their own service stations running because it's more efficient to run their own than to contract out to the dealers.
Right, so literally, I'm a dealer. Like, think about this from Professor Burton's perspective. What was the bargained for exchange in these franchise agreements? What's each party getting?
The dealer gets the gasoline, and then the Shell has to set the price in good faith.
Yeah, and Shell has to set the price in good faith. The dealer gets the gasoline. Why would you enter into a dealership contract?
You want to sell gas, but you're not the refiner. You don't.
Yeah, but of course, there's another way you could get gas. Yeah, so if you just want gas, you could get it off the rack, at least is what they're doing. So why would you enter into a distributorship agreement? Aiden.
It's because they're a franchise, so
Yeah.
Shell's probably taking some of the overhead costs.
So Shell's taking some of those overhead costs, and why would it matter to you that, go ahead, Skylar? You benefit from their brand and name, and Skylar, you had your hand up as well? Didn't say the same thing as well? Okay. So you benefit from their brand, their name, overhead costs, right? All of which mean, go ahead, Liam.
Well, I was just gonna say you don't have a truck, so you want to use.
So maybe you want to use their trucks, right? All of which are saying you're doing this because it's not like you don't want to not be in business. You're doing it because you want to be in business and because you think that your costs are going to be lower doing that. They didn't say that. They didn't guarantee a lower price than the off-the-shelf stuff. By the way, what do we tend to call it when, like, this is an amazing thing. So mile marker is 217 on I-81 is one of your places to get gas. If you happen to be headed up, it's right beside my house, so wave as you go by. But the reason that it is there is because there's one of these Circle Ks, and then right across the road is like one of these little tiny Liberty stations. And that Liberty station, as far as I can tell, is just there to troll the Circle K. They don't lose much money because they don't serve up much gas. It's like, I don't know if it's like a money laundering thing or whatever, but like I've hardly ever seen people at the little, like the station across the way. But by golly, they are constantly just like, undercutting that Circle K. What do we call it if a big corporation starts doing that? Like, this is why Walmart destroys local businesses. Anybody? Discounting?
Is it called pricing out or something?
Yeah, there's pricing out. It's also, you call it a loss leader, right? Where you're just like, you know you're selling it as a loss. You're just doing it to drive other people out of business. And by the way, let's say you succeed at doing that. What do you think happens to your off-the-rack prices? Big surprise, right? I like the eye roll that I'm getting from Liam. He's like, well, they go up, right? Like, obviously, these scumbags are going to do that. And so you see the problem here. They're forcing their own franchisees out to engage in monopolistic behavior later on in order to capture the market. That's not cool. Now, having fully established how deeply uncool that is, what's the strength of the response? Because the response here wins. They basically do, like the plaintiffs basically do have a smoking gun saying you are intending to exercise discretion that you have under the contract to deprive us of the benefit of our bargain. Professor Burton is quietly screaming at this point, right? And what's their response?
They pull the lever to sort of described bad faith as just being discriminatory pricing.
That's right.
Not what they were doing.
That they're not engaging in discriminatory pricing. That is by category. They're not saying one dealer is getting a worse than other dealers. They're just saying all dealers are treated the same. All off the rack is treated the same. By the way, that's an interesting move. Anybody want to say they're playing games with the meaning of the word discrimination?
I was gonna say they're discriminating against their own.
They're discriminating against their own dealers. I am sure, actually, I was going to say, I'm not sure why the court adopts a pretty clearly silly interpretation of the word discrimination, but there actually is a reason for it. And what's the reason they give for saying, no, I get it. Even where there's evidence of subjective bad faith, and there is, we're going to say your price is objectively reasonable.
They say it's within the reasonable market comparisons, and also there's no way that Shell can guarantee a competitive price for every dealer, so there's no way that they can guarantee that every dealer is going to make money.
Yeah, they're not.
Saying sorry, it's not our fault that you guys are going broke.
I mean, although it totally is, right? But it's, yeah, that's exactly it. They're saying this is a posted price within the commercial range. Now that's the black letter law. This is official comment 3 to 2305. And what it says is, if there is a posted price that is within the competitive commercial range, that is deemed presumptively to be a reasonable price set. And you can kind of see why, right? Imagine, I'm trying to think like Aldi. So Aldi right now, and then if they catch me doing it, they're going to raise their prices. But they are my last source of not ruinously expensive Greek yogurt. And because you can get one of those Greek yogurt things for about $2.55, which is just mwah, right? So let's say though, you go and you load up with Greek yogurt, right, at $2.55 a bunch, and I need my protein, so I get about 8 of these things at a time. Unless I'm walking out, right, and I hear the sales manager of Aldi going, "Wah, we are intending to sell this at a price that is going to ruin Joshua Fairfield."
I don't have anything to say about it.
Yeah, I don't have anything to say about it either. It's just it's the best price in a competitive market. Okay, you're a really lousy Mr. Burns. You suck. You have failed, Your Majesty, right? It's just bad. I don't care if I have subjective evidence of your evil intent. Maybe you're going to give me another myocardial infarction or something, but other than that, that's the point they're making. They're look, if it's a competitive market price, we don't really give a damn if you had evil intent behind setting a completely fair price. And that's the case. Any questions? So here, by the way, if we were to back up into the prior case, our Summers theory versus our Burton theory, which theory? Burton won the last round. Who wins this round? Summers wins this round, right? The objective theory wins this round. A fair market price. The price you're going to look up in the public catalog of prices, that fair market price is not an abuse of discretion in setting prices. It's just the fair market price. Or competitive, I shouldn't say fair. Fair is a 4-letter word in economics. Bailey.
This is a little abstract, but on page 366, it talks about how the contracts with dealers don't require them to buy Shell gasoline exclusively, but it kind of eliminates the only major alternative source. It feels very Eastern Airlines.
Yeah, it is. Oh, it's this.
How does that connect with that? I guess because I literally later on it feels like it's very opposite to Eastern Airlines, the way that it kind of pans out.
Well, Eastern Airlines says requirements contracts are okay under the UCC for consideration because you have to set your requirements in good faith. And then they said, oh, by the way, although I think this is actually similar to Eastern Airlines in this sense, obviously cases are the same on some axes and different on others, but it's the same on this. Remember in Eastern Airlines where they were complaining about fuel freighting, right? And they're saying you're loading up over here and then you're transporting the fuel over there, and that's causing us to get more and more losses because you're buying it where it's cheap over here. And the court's like, yeah, but that's industry custom and practice. That's standard in the industry, which is the same move we're looking at here. Gene.
Also slightly abstract. Do you think that the court's decision in this case kind of rests on the fact that this is in Texas and oil is kind of their thing?
Certainly they lean hard on what is your industry doing? Which should come as a surprise to absolutely no one by this point in a UCC contract. And like, where is your industry if not in Texas in the United States, right? So they're going to be more than willing. Like, it's certainly Texas is probably a better track for oil price stuff than, I don't know, frickin' Oahu, right? That doesn't seem to be ground zero for the asphalt and oil industry. Seems to be a legitimate move, right? Probably more legitimate than the last time we saw Shell, which was when they were fighting in Nanakuli. Yeah.
I'm wondering if the plaintiffs, the gas station would have had an argument here if they said that the jobber price is clearly the market price and that there's like this clear discrepancy, and so they're kind of trying to establish.
Well, they did, though. I mean, like, it's clear that they're selling, if not at a loss, then at an even lower price for the jobber rate. And that's weird. And they've also got, through discovery, I assume, evidence that they're doing it intentionally to drive their own franchisees out of business, which, like, sucks as a basic principle, right? It's not a great look for them. But again, the court allows the objective theory to override the clear subjective evidence of wrongdoing.
They couldn't have like an unconscionability defense. They could have an unconscionability defense, although as we will see, unconscionability has the same and very strange split. I guess I'm just going to ask you to hold that until we get to unconscionability. Traditionally, old school unconscionability would only apply to a deal, and they use words like, the older cases use words like gentleman. So we're talking fairly, like no gentleman would enforce, right? But I'll update that for modern language. No sane human would accept, and no decent human would enforce. That's the standard we use for unconscionability, old school unconscionability. That is, it's a weird one that falls out of the norm. Well, setting a standard market price is not a weird case that falls out of the norm. In our post-Easterbrook hellscape, it is the norm to have clauses that take away everyone's rights. And courts have begun to adapt the doctrine of unconscionability to handle those. And so that's a separate branch that looks a little bit more like Burton and a little bit less like Summers. So keep an eye on that ball when we get to it. It's a great question, but we're just going to have to wait till we get to defenses. Okay. Any further questions on this one before we move on? Rock on. Then let's keep cranking. All right. Valeria, would you mind setting up City of Midland for me, please?
Okay, so basically it's like 5 police officers, most of which had like some health conditions. They did these like lawsuits against the department of the city for violations of the ADA and the Texas Committee on Human Rights because they were reclassified to civilian positions after like there was some budget constraints. And these civilian positions had less pay and less benefits. And so they asserted that the civilian assignments were like more endangering to them. They ended up dismissing these lawsuits, and then like so they're in these civilian positions as like retaliation. That's what they think. That's their theory. And so the question here is like whether there's an implied duty of good faith and fair dealing in employment agreements, because it was like an employment agreement, and that's what they're suing. They said it's like not good faith for you guys to act in retaliation against us for suing you guys for discrimination. And here the case law kind of said that like not every contractual relationship creates a duty of good faith and fair dealing, and there needs to be like a special relationship, like an insurer and an insured, where there's like severely uneven bargaining power. But that's not the case here because it's an employment agreement. Because like with an employee, they can go and find a new job, but an insurer once they already have like an accident, they can't just like go to another insurer to get that fixed. And also the legislation had created its own whistleblower laws. So, and they had their own procedural requirements that the police police officers didn't actually like go through, like they had like a list of things you had to do before you sue, I think.
Mm-hmm.
They didn't do those, so it was like you guys are just kind of trying to circumvent what the legislation had already put in place. And so there's just not a special relationship, and they don't want to subvert the statutory scheme put in place by the legislators. So they say that there's no like implied duty of good faith or fair dealing for employment contracts.
Wow. All right, we're just going to move through these pretty quickly. That's absolutely right. The black letter law of the case is that there is no obligation of good faith and fair dealing in employment contracts. And indeed, except in a minority of jurisdictions, that turns out to be a pretty generalizable rule, that there is no duty of good faith and fair dealing in employment contracts. We're going to have to get to the bottom of why. Let's first talk about what the court says, which is unmitigated bullshit. So the court says, first of all, I feel like, what law are we under? The common law, and why?
Because it's like an employment agreement, there's no sale of goods.
Yeah, it's an employment agreement, there's no sale of goods. And I swear I just remember reading something about implied duties of good faith under the common law. And what was that? What's our restatement provision that we're still working on?
Honesty in fact, and then following the industry standards.
So that's going to be our UCC definition. That is 1201B20. That's our UCC definition. That's right. Where do we find this duty of good faith in the common law? We find it in Restatement 205. And does anybody happen to have Restatement 205 relatively easy to hand? Go for it. What's it say?
Every contract imposes upon each party a duty of good faith and fair dealing.
Wait. What was the first word of that sentence? By the way, you're absolutely right. I'm just cheering. I'm just doing this for theatrical effect. Every court. Can you? Okay. But at least now we see we've uncovered something, right? Because now we're like, the court is now making stuff up again. Why are they doing this? Because there's a quite good reason. Anybody want to have a guess? The court's like, da-da-da. Because if there's a duty of good faith, then we've destroyed the at-will employment rule. And so the court doesn't have the guts to just say that's what's going on. It's obviously what's going on. Your mileage may vary as to whether that's good or not. I don't know. But the court does touch on it with this idea that they're free to go get another job, right? Well, what's that about? The free to go get another job thing, that's your at-will employment rule. Okay, the court's preserving the at-will employment rule. Here's what I need you to know. If you ever find a jurisdiction that does impose a duty of good faith and fair dealing within an employment context, you've now got a legitimate argument for termination for cause only. Now, that's not termination at will, but termination for cause. That's how you tell states that don't have the at-will employment rule, is you look for a duty of good faith in the employment context, which is also unsatisfying, right? Because is it necessary to abolish the duty of good faith and to just straight up not tell the truth? Like the court's saying things like it requires a special relationship of trust. To be perfectly clear, that's called fiduciary duties. That's a completely different deal that has nothing jack all to do with a duty of good faith. The court's making that part up. But could we have preserved a duty of good faith for employment context and preserve the at-will employment rule? Could the court have done this less clumsily? Yeah.
Couldn't they just say that the contract between an employee at will would have good faith until the termination of that contract?
Yeah, right. This is just not rocket science. It's to say this does not extend to termination. There's your at-will employment rule. To say we can terminate you for any reason. It does not have to be a good reason. We can terminate you for any reason. But what are some places where we would apply a good faith obligation in employment, perfectly consistent with the at-will employment rule? Yeah.
Firing somebody for not breaking the law.
Well, yes, but that's still firing, right? And that we handle under public policy, right? Because you're right, we do need that fix. We can't just say, oh yeah, I ordered you to murder somebody and you didn't, so now I'm going to fire you. The problem there is that under our discrimination framework, it's way too easy to say, oh no, I just fired you because I didn't like your haircut, which is a perfectly good reason to do it, right, under at-will employment. Whereas, and they're like, no, you fired me because I refused to commit an illegal act. And this is really hard to prove. But we do have to fix that loophole. We do that later on. But I'm talking about like, no, we could say at will employment still's there. We can fire you for any reason, including bad haircuts. We can fire you, but there is still, for some things, is an obligation of good faith. What would we apply those to? Yeah.
Like pregnant women, or I guess maybe like getting a chronic illness or.
By the way, do we handle things like gender discrimination through good faith in employment? No. How do we handle those? Anti-discrimination legislation, and this is why we have to have it.
You can say that, like an example of good faith would be not like changing someone's salary arbitrarily.
So maybe we could say things like you can't change somebody's salary arbitrarily, or you can't subject them to unfair but otherwise non-discriminatory working conditions. We do almost all of that with legislation, right? You know, like for occupational health and safety stuff. But you could imagine saying like, you know, paying someone in a timely fashion, right? They've done the work, you've got to pay them. There are places where we can say, you need to be executing our agreement fairly, you know, not depriving me of benefits, like wage theft. You can imagine a world in which good faith in employment could be used to prevent wage theft. And that would be entirely consistent with the at will employment rule, because that's that retrospective, right? You're saying for services already performed, you have already promised to do these things. You can't yank that. Bonuses would be a big one, right? You can't promise me a bonus and then yank it away if I do what you asked for to earn the bonus. And then you're like, ha ha, market conditions have changed and our CEO needs $200 million in compensation this year, which is why we're giving you nothing. That kind of stuff can't, like you could imagine that could be good faith, consistent with the at-will employment rule. They didn't need to make the claims that they did in this case in order to preserve it. Nevertheless, it is broadly true that in most states there is no obligation of good faith in employment contracts, precisely because courts are acting to preserve at-will employment, which is what sets apart all of these labor cases. It is not a general rule where you have to find a special relationship in order to get good faith. Every contract has one, just not employment. Further questions on that? That's what that case is doing in the book. Cool. All right. And then last but absolutely not least, and after this I will be asking for volunteers, Ben, would you mind setting up Carpenter for me, please?
Yeah. So Brian Carpenter went to CPW to buy a car, well, two cars, one for himself and one for his daughters, Kendra and for Carrie. He was not confined to Chrysler or Baron. It's basically advertised to him by the salesman there. The salesman tells him this is a reliable car. It will do everything you need. But this car will satisfy everything you have to do. So without test driving the car, he buys it. He takes it home over subsequent months. There are multiple issues with it. He has to keep returning it for repairs. Eventually gets to the point where he stops making payments on the car. He finds out from Chrysler that it was actually used for a like employee testing program, basically where they unplugged the odometer, so they never actually have mileage on it. So at that point, he gives up, quits. So CPW revinds the car, sells it to somebody else, from there, Carpenter. He sues.
Yep.
And sues under. Oh, sorry. Hold on. Yeah. So basically, from here, the issue was representation of the fact that the quality or value of the good create an express warranty statement of the fact, not opinion. Okay. And the court rules, statement of the fact does count as an express warranty, because whenever he was going through the purchasing process, he had been told that it was going to be reliable, which the court found was still within
Yeah, like it's fulfilled in each warranty.
Okay, that's, man, what do you guys, what do we put in the water here? You guys are just nailing these cases. We're really going to be moving through them with some serious vigor today. Yeah, absolutely. So let's just do it by the book. What law are we under?
We're under UCC.
We're under the UCC, and I'll be that pedant. Why? Because it's a movable good, because the car is a movable good. Great. We're under the UCC. Now, here's the harder question about what this is doing in this part of the book. What statutory section are we looking at here? What's his argument? Because this is the first time we run into your next big study topic, which is going to be this cluster of 4 statutes. Okay, which one are we talking about here? Yeah, sure. Anybody want to take a crack at it, Liam?
2, 3, 13 through 2, 3, 16.
2, 3, 13 through 2, 3, 16. Leland, which one is it?
2, 3, 13.
It's 2, 3, 13. Well, let's get 2, 3, 13 under our noses. What is 2, 3, 13? And I'll just open this up to anybody. Liam?
It is a warranty that is implied by some representation, and then also a fact that was asserted.
Okay, you win at law school because you've given me the perfect tee up. We have a problem. What's the title of 2, 3, 13? You're right, but we have to. But it's complicated. Express warranty. Here, this was actually the purpose of me asking this question, right? Here we are talking about implied warranties, right? In what sense is this small I implied? And then I will clarify definitions so you do not get confused. To be clear, this case is not about an implied warranty, as lawyers understand it. It is about an express warranty. We need to understand why it's in the implied section of the book. Anybody want to take a crack at it? Jake?
Is because the salesman didn't specifically say, like, there's a warranty on this vehicle, but everything he said was basically saying that the vehicle would be up to the buyer's standards.
Be up to the buyer's standards. And Alligator? You assume, so those are our 2 theories, y'all. Whoa, we just heard it. We just heard the difference between 2, 3, 13 and 2, 3, 14. 2, 3, 13 is the dealer said something, and that becomes a term in the agreement. What this is doing in the book is because the words we are talking about, what's the real relevant word here, Ben? That describes the car that gets this dealer in trouble? Reliable. That word reliable is not in the damn contract. Where does that express term come from? From the guy who's selling the car. He's saying something. What kind of evidence is that? Hearsay. No, wrong class. But close. Oral, which means that we're going to have a problem proving what he said under the parole evidence rule. We're going to have real problem. This is how this all starts coming together. We're going to have real trouble proving what he said past the damn writing, which if the writing is a final written agreement and is integrated, we're about to have issues getting this language into court. Now, this case doesn't focus on how we got this language into court. We can talk about that later. That's not what this case is about. But in the back of your minds, you should be asking, the hell did he get this representation into court? How did this happen? This is straight textbook 2202. The parties had a final written agreement. Reliable wasn't in the book, wasn't in the contract. Now that's different from 2314, which is something nobody says, but parties are allowed to assume that things that they buy from merchants who sell stuff like that is merchants and goods of that kind. This is our Uber, this is our Super Saiyan merchant, not just a merchant under 2104, but a merchant in goods of that kind, a merchant who sells this kind of stuff. All right? That kind of merchant can make a warranty and nobody says anything. Just, I assume this car will go. I assume it will drive. Y'all, everybody is going to analyze almost every fact pattern for 2313 and 2314, and wait till we get going. and 2315, and then try to figure out whether or not any of those warranties were knocked out under 2316, which I'm about to ask in a second. Those 4 statutes hang together, and it's the same fact pattern, which makes this the single most testable question that anyone can possibly ask in this class. There will be one on this. I don't say that as a promise. I say that as I don't think I've ever written an exam that doesn't have it, and it will be all over the bar exam. Just all over it. This is the single most testable thing ever. Now, what we should understand by this point is that this is about an express warranty, but it's a hidden express warranty, if there can be any such thing, because it's not in the writing, it's in the oral representations. Let me just ask you about oral representations though, right? Like, so if they'd come in and the guy had been like, hey, I'd like a car, please. And the dealer had said, oh yeah, this car is great.
That's fine.
That's fine. Why is that fine?
Because he's not making any sort of like statement under, he's not making a statement that's on the code, this will do what you need to do, or there's no like obligation there basically. But like, oh, this is going to fulfill the needs that you want for.
Right.
Great, it's just open.
Great. And to be clear, there's language, there's legal language around words like great. This is called, quote, and write it down, mere puffery. This is how lawyers talk about this. Mere puffery. You are simply saying your product is good. I was reminded of a financial services group, which will remain unnamed, who one time came and like presented a number of their funds to our finances committee, and one of them was a very, very bad performer, and we're like, this is a very bad performer. Why are you trying to sell this to us? And they're like, but we believe in it. And we're like, okay, like I get it. Mere puffery, but also don't do that. So yeah, that's mere puffery, that's allowed. All right, now we just gotta work with gradations here. I will use some very weird words. These are drawn from Dan Keating's Sales upper level book. I did not come up with this, but I just think it's weird enough and funny enough that it'll drive the point home. Let's say though then that you come in and you say, I'd like to buy a car, right? And they say, well, you should buy this Chrysler LeBaron. They're like camels. No, I know. This is not why I was telling you this is not my example. They're like camels. Yeah, I don't know what that means either. But let's give it some more meaning. So still kind of mere puffery, also probably eccentricity, right? Deeply weird people. All right, you come in and you say, hey, I need a car that gets at least 35 miles a gallon. And he says, well, let's try this LeBaron. They're like camels. I don't know what a camel gets either. I do not know what camels per draft of water. What's at least a theory? Words gain their meaning from use within a community and context. Having given additional context, what's our theory? Yeah. They just keep going, that they have long stuff. So do you know, so now let's just back it up one. Now that we understand what this weirdo thinks when he's saying they're like camels, what's the difference between the first statement and the second? And the reason I'm hammering this is because this is what will be on the bar, and this will also be what is on my bar. Yeah, what turns it, and this is how they always couch it. Because look, if a person just makes a definite statement, this car gets 50 miles a gallon, we know that's an express warranty under 2313, right? What's the difference here, Justin? Yeah, and here the preceding statement gives it its meaning. That's usually how they're going to frame this question. That's how they're keeping that express warranty as hidden as possible. An affirmation of something that somebody is buying something says, usually these express warranties are going to come from something that the customer says and the salesperson agrees with. And then that additional context gives meaning to the word and turns it from a sort of a weird statement about mammals to, oh yeah, well, you're clearly affirming the idea that this car gets a good gas mileage, right? And in this case, the guy comes in, the guy says, what to the dealer before he makes these general, because see, here's the thing. If I said, I would like a car, and he comes in and he says, this is reliable. Is that an express warranty? Like, no, and then anybody want to say, yeah? This model. You see it? You see the problem? Go ahead.
Well, if you're talking about just the model generally, then you're not referring to that specific car.
Sure, but also because that car is that model, you might be deemed as making, like you could say, these cars, these Civics get this gas mileage, and then if this particular Civic doesn't get it, that's an express warranty. But you're right to be like, there's too much give in this. I don't know is the right answer. I'll take money to argue either way, but I am not confident about winning that. Like, is reliable like great? Is it mere puffery? Reliable has no meaning in content until we start adding, this is the model specification. This is what this car can do, right? Those are all some giving content to it. All right, that's my only point there about that. That turns out to be important later on, that the fact pattern will very often be the customer says something and the salesperson confirms it. And I just need you to realize that's how it's usually going to happen, because that's also going to be the major point of confusion and double up when I ask one question and I'm actually testing you on 313, 314, and 315. And this fact pattern is also the same fact pattern we use for 315. And the answer is understand the different legal theories and do both, and you'll get all the points. Because almost every question is going to be set up so that you can do both. And probably all three. Probably all three with 2, 3, 14 thrown in for good measure. All right. That's all I need you to know about this particular case. This is 2313. It is it is an express warranty. There's only one last thing to kind of pick on with it. Anybody want to guess? The word reliable wasn't in this contract. I'm going to say that there are some words that were in this contract. Anybody ever bought a car? Yeah. What words am I looking for that's in pretty much every damn used car contract or car contract period? As is, or with all faults. Okay. That is an express, that is a specific attempt to use another statute, 2316, which we will go through in detail and which you need to know like the back of your hand. But for now, I just want to say it is possible to disclaim your implied warranty of merchantability. For example, as is, or with all faults, that language, will wipe out any implied warranty of merchantability. We haven't gotten to it yet, 2314, but having gotten to it, it's almost always going to die because almost every contract is going to say as is, with all faults. And at that point, 2314 is gone now. Same for 2315, also gone. You'll see this language. Seller disclaims all warranties of merchantability and fitness for a particular purpose. They're disclaiming 2315 as well. Why didn't the language, assuming that it was in this case, as is or with all faults, why didn't that block this weirdness that this rogue salesperson is going out there saying your cars are reliable? Why doesn't that act as a disclaimer of this express warranty?
Was it because there was like a power difference, like the carpenter was rendered disarmed and made credulous by his previous purchase?
By the statements, I think is the one thing. Just as a matter of law then, 2316.1 says it, although when you first look at it, you will not see that it says it. We'll have to go through it. But 2316.1 says you can't disclaim express warranties. You are not allowed to say yes and then no at the same time. That doesn't work. If you say yes for a limited period of time, if you say yes, it is reliable for 90 days, that's fine. Those two statements are consistent with each other. But you cannot say, yes, it is reliable, and by the way, no, we are not making any representations about it. Those are inconsistent. And so under 2316.1, you cannot disclaim an express warranty, which is one real reason then to make the argument of an express warranty and get it passed. This is one of the reasons why this is the strongest of the three. This is the strongest of the three because it survives 2316, these routine disclaimers that try to knock all of these things out. All right, if that's true, if it is true that you cannot disclaim them, can anybody advise the poor car dealer in our last minute? How are they going to stop rogue salespeople from making all of these representations, which are nowhere written down? And how are they going to protect themselves from getting hauled into court based on, like, salespeople, imagine, like, I know this is true of software salespeople. I won't say anything about car salespeople, but software sales, they will say that the software will do anything short of raise the dead. Yeah, absolutely, it'll do that. How do you protect yourself as a company against these people going around and making these representations? No reasonable person would believe them, so you can attack that prong in 2313. We have to make the representation, and then it has to be part of the basis of the bargain. Yeah? An integration clause. What are you using to block it? This is brilliant. What are you using to block this representation, this oral representation by this? Yeah, you're using finality and an integration clause to block it under the parole evidence rule. To block it under the parole evidence rule. Do you see that? You can't disclaim it, and this is something that really is hard for students to get through their heads. You can't disclaim that express warranty. It exists, but you can block evidence of its making from coming into court under the parole evidence rule. Try this. Remember, the core rule of parole evidence is, even Justice Traynor will say, you can't introduce evidence that contradicts the language. So, what do you say? To lock up this solution, which is absolutely the right answer, to lock up this solution, you say, seller has made and buyer has relied upon no additional statements of facts other than those that appear on the face of this document. Now, that's a lie. It's a bold-faced, flat-out lie. And the express warranty was made anyway. And it cannot be disclaimed. But there's no way in hell external evidence of the making of that promise can be introduced past a contract that is final, integrated, and upgraded like that. All right? That's where we'll leave it. Thanks for giving me the extra minute. We'll pick it up.